Property Summit. As you are aware, this summit has been a regular event in the last 6 years and has been very popular and has been drawing a lot of well-established speakers over the last 6 years. This afternoon too, we have three well-established speakers and members of the corporate world who are here to share their knowledge and experience on this field of intellectual property. They are also, to their acclaim, holding various articles or publications, as well as have been actively participating in summits like these. I'd like to mention the first of our panelists is Dr. Paresh Kariya. Dr. Paresh Kariya is Director on Otis India Limited, and he's a senior corporate leader, research referee, arbitrator, author, chartered engineer, approved valuer of plant and machinery, and a well-established person who's been dealing with various multinational corporations in the field of environment, health, safety, quality, customers, communication, then project management, valuations, and market research. He's been also associated actively, apart from with Ahmedabad Management Association, with the Rotary Club, JCs, FICCI, and associations principal to us like IMA. His keen interest lies in understanding value dynamics, research, methodologies, and providing support to the business community. Creativity in research motivates him. He has been actively involved in corporate leadership, training, coaching, guest facilities, and advisory positions to companies, entrepreneurs, and institutions. Welcome, sir. I'll just briefly introduce all three, and then we'll invite you. Our second speaker is Mr. S.K. Shah. Mr. S.K. Shah is a Commerce and Law graduate and is a fellow member of the Institute of Company Secretaries in India, and has had more than 20 years of post-qualification experience, which encompasses various industries, primarily pharmaceuticals, chemicals, finance, steel, hospitals, and certain FMCGs. Mr. Shah is actively involved with corporates like the Zydus Group, then the Paras Group of companies, the Maradia Group of companies, and also because of the Paras Group, actively associated with the Sterling Hospital. Mr. Shah was the Vice Chairman of the Ahmedabad segment of the ICSI, and has also been actively participating in seminars like these. The third speaker we have here today is Mr. A.J. Sher Dalalwala, who's a very young corporate entrant in Ahmedabad. He's 4 years of experience with his parent company, which is now, or rather family company, which is C.R. Sher Dalal and Company. He's a third generation chartered accountant and has joined his family after having varied experience after his education. He has worked with multinational organizations over his internship period and has been actively associated and worked with Deloitte Touche in the financial advisory arm in Ahmedabad. While he was also studying his chartered accountancy, he has been actively involved with ICICI Bank in the international banking group. His areas of expertise are audit and assurance and financial advisory. He too has been quite involved in writing because of his experience in this field, and he has a couple of articles which have been winning good acclaim. One of them is titled on the company's amendment rules of 2009, amendment to AS 11, and another one has been written on the Limited Liability Partnership Act of 2008. Sir, I welcome all three of you, and we trust it'll be a wonderful afternoon. As we play the timing, I would say we'll first let each one of you give your presentation, then we can have about a 20-minute question answer session and an interactive session which we can involve you as well as the audience. I take the opportunity to welcome you with some flowers. Kariya, can we have?
Okay, very good afternoon. Am I audible now? Voice is clear? Okay, very good afternoon and warm welcome. Let me give you a big thank you note to each one of you, showing your keen interest. My thank you note to Mr. Trivedi, AMA team, and I think all the speakers on the dais. I think today I'll give you a little bit of input because see, I am also in the industry. I'm basically from a user side on this subject. You're getting my point. So my views will be different. So you bear with me. If you don't digest, don't worry. We'll discuss, right? Let me start with my input on what I think and my community think when we go for M&A. We think that, or we assume that all IP rights automatically transfer with the purchase of asset. This is what is our granted assumptions when we go for M&A. And even assume that IP has a little value to the total, you go for M&A or transaction. So this is what is a fact, hard fact as a buyer. But over a period we learn the truth is virtually every deal involves some type of IP assets. And there are many IP issues. If not explored and properly studied in depth during the due diligence process, then it can be a deal breaker. That's what we learned the theory over a period. Because my journey in corporate is almost 23 years and last three and a half years I'm involved in this subject, buying assets or you can say M&A or going for a joint venture or partnership. So this is what is the fact. My understanding of IP, again I want to reiterate here that I understand IP means patent, copyright, trademark. I will not go into the detail, I know you all are expert. But here what I wanted to highlight that non-traditional forms of IP is the area where I need a lot of help as a buyer from my expert community. Basically trade secrets, domain name, website screens, business methodologies. We always say that process is the king, especially in our business. So business methodologies are very, very important. And some of the differentiating taste and smells and sounds. So this is non-traditional part of IP which is impressing too much on me during my journey of this IP. My input today on this session will be what are the due diligence pointer where we are very proactive nowadays, especially in the context of M&A. And let me give you the input one by one. We cannot underestimate, that's what we now understand IP. And IP has competitive advantage, that's what you all know. So what I have done is I have done a sampling of top IP issues based on my exposure and experience. I am not expert on the field, but this is what my input to this part of the community is, my exposure and experience and a sampling of top issues on IP. And let me start number one. When we go for this journey of M&A or buying the assets, and sometimes during your due diligence, we come to know that target does not actually have the critical IP rights, which target is claiming and claiming the valuation of it. Sometimes they overstate its patents or their IP holdings. So This all theory comes from the due diligence. Or maybe they have some litigations which we don't know. Sometimes the issue comes up, they are the co-owner, not a sole owner. Co-owner, not a sole owner. Sometimes there are inbound license agreements which don't allow for a further transfer. And here we are considering this as a part of the value in the deal. So these are hard facts which we learned. I can say all this presentation here is learning hard ways. What all I'm talking here is my learning hard ways. I think you are lucky guys, you'll pick up directly, right, if you're going for it. And legal and IP expert help is must. That's what lessons we learned in corporate. Because I started first slide that we, earlier we used to assume that this is automatic here. We are buying your, operations or maybe the factory or entire, distribution of the business. Everything is automatic, but no. Due diligence is very, very important. Point number 2 of hardware learning is outbound license agreements give a key rights to another. So this is also important area, that is there any outbound license agreement done? And then sometimes, the target may have already licensed some or, all of the IP rights to another party. So this due diligence pointer, what I'm saying, is very, very important. Let's move further on pointer number 3. Hardware learning. Target is or has been subject to pending or threatened infringement claims. This only comes up when you go into a detail aspect, or you can say you take the help of the experts and in-depth due diligence. So what the buyer definitely wants to avoid is the purchase of expensive litigation liability. When you are buying this asset and you land up into point number 3, then you are buying a litigation liability, which is post-deal sometime, not during deal or not pre-deal. So this is a very, very important pointer I wanted to share at this point of time. So basically all the buyers want to avoid the unexpected litigations, because nobody would like to buy legal challenges. Everybody is buying in a good faith. This is a nice word we use in our corporate journey when we go for M&A. Good faith is the real fundamental to start the journey. But under this good faith, I think this due diligence is very important. Otherwise you'll end up into a litigations. And the risk, a lot of risk is part of it. So I think opinion of counsel is very, very important. Pointer number 4, again hardware learning. IP rights owned by the target do not match the business goal of the buyer. Like my personal example, when we go for our M&A, we have our objective. Maybe somewhere our objective is that the brand is doing good. So brand has a power. So we want to take care of, pick up the brand and develop that brand as a second tier brand. Like our sole brand is our company brand. But we said, okay, let us develop another brand, which is strong brand in that part of the area, and maybe we can take it further. Like outside India, we did one, acquisition of the company, and that company was a nationwide company in Asia. And the brand is very strong. Now we are thinking, let it bring it to India. But when we took opinion of our legal counsel, there are some issues. Okay, so this is what I want to say. IP rights owned by target do not match business goals of buyer. So that alignment is very, very important, because you are investing a lot of money behind the deal. Pointer number 5. Significant non-barrier exists to exploitation of the technology. Now this is a big subject. Here sometimes, even your IP experts or your legal counsel, they also depends a lot on your knowledge as the entrepreneur or a business guy, because technology much better than the legal counsel. So I think this technology aspect, like third parties may have patents that prevent the buyer from exploiting the technology or easily expanding the operation of the business into a new or more profitable areas. And today you all know that a lot of reverse engineering is happening, and people are very proactive to go and register their rights. And when you go and approach, it's too late. So I think this subject is catching up, if you ask me. And corporate level, even we are developing a lot of sincerity. Maybe my input, I will tell you that now at our company, we are thinking that why not we have a separate department to take care of this asset. Intellectual asset is also a big part of, it's not only the brand value, but a lot of other aspect of IP. We have to put it in a form of quantifications and the values. So my input here in summation here, that careful attention to all these items, which I shared with you, learning hard ways, and quality communications between the IP lawyers and the corporate lawyers and the ultimate clients are very critical to ensure that we as a buyer plans and strategize, fully understand and appropriate IP due diligence. And this plan must be implemented. It should not be only on the piece of paper. I think execution is very, very important. And today there are targets. Like if you ask me, a multinational company where I'm working, we have targets, time-bound targets, to acquire certain assets in a calendar year. So the time is more than money. But having said that, this due diligence execution is must. It's part of the process now. And now there is again one more slide I wanted to add, evaluation of this role of IP in M&A. Maybe the initial part, the IP as a risk factor, identification and allocation of IP related risk. But now the second generation and third generation going further, IP as now a value driver. It's the real value driver, and integrating IP into a deal pricing calculations. I think my chartered accountant friend is here, right? So he knows much better that it's part of the deal calculations. And third generation IP as a deal driver, meaning that target selection based on the IP. Everybody wants everything clean, right? So clean IP asset is also a part of now M&A deal. So this is what is my brief input. I think we'll have a good session, I think, after a couple of input. So here I just take a pause and go back to my place and allow other speaker to speak. A big thank you.